have to claim for whatever legal reasons then and there, and remitted and awarded the plaintiff around $80,000. A judgment was entered pursuant to that order around in November 2021 for a total of $93,107.60. And then both the order and the judgment have been entered via notice of entry on NYSEF, and service and affidavit of service thereof has been also uploaded. The time to appeal both the decision and judgment has expired. And pursuant to the judgment, as is a creditor's right, we served defendant with a set of information subpoena and restraining order, along with subpoena ducis tecum to appear for deposition pursuant to Article 52. And just aside from some communications from now defendant's counsel, we have not, just debtor has not appeared to the depositions, has not responded to the information subpoena, and to our knowledge is not obliged by the restraining notice. As such, we move for the adequate remedies afforded to a judgment creditor in the state of New York.
Okay, and like you said, it sounds like facts are fairly simple, which is always a plus. All right, let's hear from Jamie.
Thank you, Your Honor. So first of all, I'd say the facts aren't quite that simple. But before we get into that, I do have an application for an adjournment. As Your Honor can see from NYSEF, I have not submitted opposition papers yet. I was retained about 3 weeks ago. I immediately contacted plaintiff's counsel to discuss not just settlement of this matter, but there's another matter for additional monies as well, and for a global settlement. I also advised counsel that I had an ongoing trial at that point, and counsel indicated to me that he would have no problem adjourning this matter for this date, as I would not have papers ready in time, and encouraged settlement discussions, which have occurred. But I told plaintiff's counsel at the time I had a deadline of June 1st to get opposition papers, and I told them there was no way I could do it due to my trial. So I'm hoping that we can adjourn this. I don't need very long, but I do need some time to put in opposition and cross move so that my client's full rights can be protected.
So Jamie, are you related to Barry? Is that his name? Barry
Sheck. No, Barry Sheck. No, I got an R. And I'm not related to the ogre either.
What do you intend to cross move for?
To vacate the judgment. It was satisfied and paid in full before it was even entered.
Really?
Oh yeah. And
well, how can
we
that
have the
be
checks to prove it?
Fact?
We have the checks to prove it.
Disputed fact. Mr. Diane, did you get a check or not?
So we did not get a check, and in terms of vacating a judgment, I have to point out that defendant himself is an admitted and practicing attorney in the state of New York, and the judgment has been entered. And not on default. It was a decision in order not on default. There was a position paper submitted last year. The judge still awarded, plaintiff order awarded, and the judgment hasn't entered and not appealed. So I can't see how there's any.
I don't understand how we can have a disputed issue of fact as to whether $93,000 was paid. That it was either paid or it wasn't.
Oh, yes. So in terms of numbers, just pure numbers, there's a running balance of a little over $200,000. This particular judgment was, as specified, Your Honor, severed vast of the monies that was pursuant to various, I believe it was a COVID law then and there. But some payments were made before the decision was entered by Your Honor, and there's still a lot more outstanding and a lot more that accrued. How our client applied it, it was not specified that it was any 20 debt. It couldn't have been pursuant 20 debt because no payment was made after the decision or after the judgment. So if anything, it went to some arrears that the creditor chose, but the debt has not been satisfied.
Did your client receive $93,000 from the defendant?
No.
Well, that's false. And you sent me a ledger the other day that shows the payment. If I may, what happened was there was originally a settlement with the corporate law firm in housing court for $81,362.95. When that was not paid pursuant to that settlement, plaintiff started this action under a personal guarantee against the individual owner of the law firm. They sought the $81,362.95 from that settlement and other arrears that accrued after that settlement. Your Honor, in his decision, severed and said he's only issuing a judgment for the $81,362.95 and not dealing with any further arrears in this case. And in fact, in plaintiff's moving papers, they acknowledged that the first payment under that settlement of $40,000 was paid pursuant to that stipulation, and plaintiff only sought, pursuant to that stipulation, $41,362.95. This is acknowledged in Your Honor's decision. But then further in the decision, and I'm not sure if this was an error or something I'm not understanding, but the court severed the other amounts and said they're entering a judgment for the $81,362.95, even though 40 of it had already been paid. But what was also happened is prior to the issuance of your decision, Your Honor, my client, either by check or wire, delivered to the plaintiff the exact amount of $41,362.95. And plaintiff's ledger, which I can provide to the court, clearly shows that. That happened on December 29th of 2020, I believe, when your decision came out after my client submitted his opposition papers, but before reply papers by plaintiff. Plaintiff did not point this out to the court. Plaintiff did not point this out when they entered judgment, that $81,362.95, that exact amount had in fact been paid prior to the decision and prior to entry of judgment.
But there was no...
And everything else was severed. Everything else was severed by this court. So as long as that amount was paid, this case and this judgment should be over with.
There was no, unless Your Honor wants to, I just need to add, as opposing counsel stated, those payments were paid in 2020. There was a long balance of arrears that were due and owing. The checks were not earmarked. It was not specified for what it was going to. The balance kept on running for whatever monies that were the court awarded the plaintiff creditor after in 2021. No payments came in the year of 2021, period. So how can any of the payments be satisfied, can satisfy a judgment when all payments were a year before and that were not earmarked, could have been applied to any arrears that were outstanding? I just can't see how a payment can retroactively, not retroactively, can
Prospectively.
Prospectively be applied to satisfy a judgment entered a year and a half later.
No, it wasn't a year and a half later. It was 4 months later. And
Well,
when you say it wasn't,
Jamie, let's stick with that proposition that Raphael's relying on. Whether the decision was right, wrong, or indifferent, payment before several months or several years or whatever, before a judgment can't satisfy the judgment, correct?
no, I would disagree, Your Honor. Again, we're talking, payment was made in December.
Hold on. Allison.
I think you're correct in theory, Judge, but I think what counselor is trying to say is that plaintiff had an obligation to alert the court that they received that money before they obtained the judgment. That's how I'm hearing.
Yes, Your Honor, and it's an exact amount. When they say it wasn't earmarked, $41,362.95 is a very odd number. It was very exact. It's not 1 month. It's a combination of various amounts. So for them to receive that amount and then say, oh, we didn't know what it was for, what months should we apply it to? That's disingenuous. They got that amount because that was the amount due pursuant to the stipulation. What plaintiff is trying to do is say, because there were these other arrears, which Your Honor severed, we can now apply any money that comes in to those other severed arrears and keep that judgment open hanging over your head.
Well,
And we disagree with that.
I think I disagree with you. Whether or not there were other monies owed and how much and how, a judgment is a judgment. You can't just say, oh, well, it shouldn't have been. You know, your predecessor counsel or pro se could have moved to, re-argue, moved to vacate. It's that train has left the station, to use the current metaphor.
Well, has it been more than a year since the judgment was entered?
No.
Since the judgment was entered March of this year.
All right, so he can still move to vacate it.
Well, he can still move, but he still owes the money
Right, so
until he
let's talk
moves.
about his application request.
So, and you're right, one thing I would also want to point out is, again, the judgment was for 81,000, even though plaintiff only sought 41,000. That was not of the severed amounts. So the judgment was already improperly in a proper amount to begin with.
Well, that's what you say. As
I
far as I'm
understand.
concerned, that's the judgment. And then, again, there are ways to attack a judgment, but not coming in later and saying, oh, we paid money before that. In any event, Allison brought up the adjournment request. Any way to settle this, guys? This is a
We tried. I made what I thought was a very good offer, and I was told there's no counter.
Well, what can you tell us the offer without?
Sure. So, and remember, this was for the all the arrears, not just this case. I don't have the ledger in front of me at the moment. I think the total arrears were about $230,000. But if you look at it, about 85,000 of it was legal fees, including for a prior case that I had properly dismissed that they're seeking. So we calculated it was $150,000 in rent actually due. And my client, whose business is failing, offered 50% of that in short order, 50,000 immediately upon signing, and 25,000, I think, within 30 or 45 days.
So,
Go ahead, Raphael. What do you think?
yeah, no, so first of all, legal fees based on the lease contract and the guarantee, they become additional rent. So I don't know. I understand. I mean, for settlement purposes, of course, we would. We are trying to work something out. And the only thing I have to just go back to, with all deference to the court, now, it was my understanding once a judgment is entered by a notice of entry and served duly uploaded and all that, then the time frame is shortened to 30 days to appeal, because it was like any other, like, that was my understanding.
Yeah, time to appeal.
5515, that and notice that the time to appeal from the entry of the yes, it's a year, but from the entry, I believe it was 30 days. Within 30 days after service by a party upon the appellant of a copy of the judgment or order.
Well, I think we're talking about
Are we
different
talking about
things.
appeals or motions to vacate?
There's motions to vacate, motions to re-argue, appeals. There's all sorts of.
Yeah.
But I'll let I just
And,
want to,
I'm sorry, just for clarification, I have the judgment in front of you. It was entered November 9th, 2021.
I think you can still move to vacate, but the judge needs.
no, I mean notice of entry was sent by us. No, notice of entry of the
Well,
judgment.
you're talking, that's for appeals, not for moving to vacate. They're two different things.
For appealing the judgment. Okay.
The offer is substantial. It sounds like we really could settle this case.
Well, it should be settled, because I don't know that you're going to do better than that, plaintiff. So I don't know why you didn't deign to give a counter, but I think you should reconsider.
No, so Judge, yes, we are reconsidering. We do agree that it's beneficial for all parties to settle this. But it's not, I do have to, it's not in that, and we do have to say that this has been very long. It's not like a one-time thing. This defendant has a track record of promising and never falling through throughout various, this goes back maybe 6 years, different actions. It usually is housing court because they were still in possession. So we didn't just want to say, oh yeah, we agreed to vacate and to withdraw our motion just because you're promising maybe in the future to pay us something. So in that sense,
No, I wouldn't expect that.
Counselor, just
It's okay. Give us a moment. We'll be back. Don't go away.
Okay.
I'm back. I try to be practical here for your sakes, your client's sakes. I have a feeling that judgment is going to be vacated. I don't like to second guess myself, but I might have goofed on that one. And as we've said, the time to vacate a judgment is a lot longer than the time to file a notice of appeal. This case should settle, probably will settle. So I'm thinking you two, and this is just my advice, take it or leave it, talk to each other, talk to your clients, talk to each other again, talk to us. Allison and I are going to set up a in-person or virtual settlement conference. What would you guys?
Oh, you want to do a settlement conference? Okay.
Let's do it.
I
Well,
think settlement conferences are usually better in person.
I do too.
Agreed.
All right.
We do not object to in person.
And let me tell you guys, we settle cases here. We get you in here, you leave with the settlement most of the time.
Okay, counselors, I'm looking at July 6th.
I'm actually going to be out of the country that week.
All right, what about June 30th?
No, I'm leaving on the 29th, coming back on the 7th.
Okay, what about
The week after, like
at 2:15?
June 15th.
The 28th?
June 28th?
June 28th at 2:15.
Oh, June 28th at 2:15. Yes, that works.
At 2:15. The only thing is, I'm gonna be in Queens Supreme at 9:30. I don't know if I don't know how long that's gonna take to get back. This is in New York. 2:15. I want to say I should make it.
I think you should be, Queens is going to kick you out at 1 o'clock, so I think you should be fine.
I'll make it. Okay, so June.
And counselors, we want your clients in attendance.
Absolutely.
Clients in attendance. Okay, so June 28th. At
2:15 with clients. We're located at 60 Center Street, courtroom 418.
418.
And if, we can help with anything before that, great. You know how to reach us, so you can figure out how to reach us.
In the meantime, we're going to adjourn the motion to that date.
Okay, and if we don't settle, I would be able to renew my application, Your Honor, to put in papers.
Yeah, yes.
Thank you.
We'll adjourn it again.
Right.
But,
Hopefully we settle.
Come in,
We're going to try hard.
Yeah.
Okay, we'll see you then.
Thank you, everyone.
Make sure you tell your clients right now, because I'm not going to entertain, oh, my client isn't available the night before.
Absolutely.
Can I borrow the for an email to best contact?
Yep. My email is ARGREE, N like Nancy, F like Frank, at nycourts.gov. So that's ARGreenF at nycourts.gov.
Thank you very much.
Okay,
Okay,
take care.
See you then.
Thank you.
Bye.